President Trump is responding today to what he calls the major victory that he was given yesterday by a San Diego-based federal judge.
Yesterday, U.S. District Judge Gonzalo Curiel rejected the environmental challenge to the president's border wall. The ruling waives a variety of environmental laws and other regulations in order to begin construction in San Diego and the El Centro areas. Today, President Trump tweeted, quote, "I have decided that sections of the wall that California wants built now will not be built until the whole wall is approved." Big victory yesterday with the ruling from the courts that allows us to proceed. Our country must have border security.
Joining us now with more on this topic is attorney Vikas Bajaj. Good to see you.
Likewise, thank you.
So the Department of Homeland Security built these prototypes, which was the focus of this lawsuit. Environmentalists said that it would disturb the environment, it would disturb habitat, and that was something that Judge Curiel rejected.
That's correct, and there were a number of plaintiffs, and the plaintiffs raised both the issues with potential harm to the environment, the getting away from the Coastal Commission and all those requirements that are there, but also constitutional arguments, a violation of, for instance, the state of California's 10th Amendment rights, okay? Meaning that the states can have their own say in what happens on their land. The interesting thing about the decision, and is by way of a visual aid, I printed it out double-sided, and it's 101 pages, and you can really see that Judge Curiel, a very well-studied and well-respected judge throughout the United States of America, actually went through great pains to say initially, I'm not judging this based on politics. Politics has nothing to do with this. So I'm going to look at the facts, I'm going to look at existing law, and I'm going to see where they intersect, whether one fits into the next. And he outlined very accurately the legislative history regarding the allowance of the United States government to circumvent normal procedures that we would have to do if we wanted to develop in certain areas that are within the Coastal Commission, for instance.
So based on this ruling, if and when Congress approves funding for the wall, are there any more roadblocks for constructing that wall from the standpoint of legal cases being filed in court?
Excellent question. And interestingly enough, if you look at the framework for this legislation, which came out in 1996, so this is not new law. It was modified and amended 3 times. The big change was 2002 when it transformed into the Department of Homeland Security. So now the Secretary of State has the same allowances and preferences and privileges to exercise his or her discretion as the Attorney General did under the old framework. But interestingly enough, the only recourse we have, or an opposition force to this decision would have, would be to go straight to the United States Supreme Court. And the reason for that is the law, as it was drafted in 1996, has a real emphasis on urgency. This is a national security issue. We should allow it to move forward if the powers that be feel it to be a righteous move.
So what are the chances that California's Attorney General will appeal to the Supreme Court?
Well, if you're asking me to look in a crystal ball, I would close my eyes and think really hard and say, I bet it's going to happen.
Yeah. So speeding up the process, I mean, what kind of time are we talking about based on what you just said? I mean, are we looking at months, or are we looking at years, or?
I would say that we're going to have a petition for writ of cert in the United States Supreme Court within 60 days.
Really?
And I think that'll preserve their rights. Full briefing will occur. The issue will be whether there can be a stay. Whether the Supreme Court will say this is such an issue of such gravity that we need to have a stay on the lower district court's order allowing it to move forward. I'm hard-pressed to believe that that would be the case. The interpretation of the legislative history is crystal clear, and that is really to move all of these obstructions to development to the side, specifically because there's a national security risk.
Well, isn't there still going to be a problem with negotiating easement rights as you go through this, where the wall is being built in California? I mean, that's a lot of court cases, it sounds like. I mean, property owners are going to say, not on my property.
Absolutely, and that's true. But again, the legislative history and the actual verbiage of the legislation circumvents that long, drawn legislation. It's much different than a situation where, for instance, SDG&E wants to take some property in order to put up poles or what have you. That's different. That's a private public utility company, but really privately held for all intents and purposes, affecting private people's land. This is the government not SDG&E, is saying there's a national security risk by having the border so porous as it now is.
Yeah. Wow.
Vikas Bajaj, great to see you.
Likewise,
as
thank
always.
you.
The president will be visiting in March to
That's right.
check out those prototypes. So more to come.
Yeah. Good information for us. Thanks.